Sir, once you had filed a caveat, sir, then you, instead of joining the proceedings through video conferencing, you should have come.
I apologize.
ये ऐसा होता है कि भाई ये first time somebody is trying to step into this business and then we can assume कि भाई नहीं है इनके पास कोई experience. हाँ सर, आप तो controversy और multiplicity of litigation में विश्वास करते हैं.
नहीं, ऐसा नहीं है.
है ना, फाइनलाइज हो गया, अब वेस्टेड इंटरेस्ट किसी और का भी अक्रू हो गया. आप मदारी बन के दूसरों को नचा के मजा लोगे, ऐसा कहना चाहते हो क्या? जी सर.
Yes, not the petitioner, Blot is a central government undertaking and is executing Blot all the major metro rail projects throughout the country. The description of which we have specifically given Blot in para 5.5. Now, Blot, here the controversy is Blot that I am not technically qualified in respect of this project Blot. Blot, I straight away not come down to clause 10.2, which is 100, which is at 104. Eligibility qualification criteria, they say EQC 104.
They have not given us a copy as yet.
We never knew you have filed a caveat.
Sir, once you had filed a caveat, sir, then you, instead of joining the proceedings through video conferencing, you should have come.
I apologize.
Because suppose if we say, okay, serve him a copy, then again we will be required to reassemble after 1 hour. Mr. Agrawal started his argument by expressing that otherwise he would not have caused inconvenience, but looking to the urgent nature, this request was made for listing. Now you people are not ready to come down to the court. Now you are making a complaint. Now suppose if I ask Mr. Agrawal to serve you a copy, then again whether we will not be required to reassemble after 1 hour.
My name did not get it.
So, no, sir.
I leave it to you,
Sir, this hybrid facility is not meant for young lawyers.
I go down to it.
It is meant for those lawyers who find it difficult to appear either because they are not available in the town or because of their health issues. It should not be used by the young lawyers who can come down to the court. But what can we do now?
I'll argue with the NIT that I have.
Okay. Mr. Agrawal was referring to page number 104.
Yes. Not this is the work experience which I am required to qualify. Not I'll read 10.
Sir, whether any reasons have been assigned?
No reasons have been assigned.
Mr. Anvesh? It is the contention of Mr. Agrawal that no reason have been assigned in Annexure P17.
P12, my lord. P12 is the impugned order at page 850.
Okay.
Page 150. 850, P12.
So this is are considered substantially responsive and compliant to the requirements of the tender conditions. And so P12 is under challenge, sir?
But this is under challenge, P12.
P12, no?
Yes, sir.
Yes, Mr. Anvesh, whether any reason has been assigned for holding that it is not technically sound or it is not technically fit to participate in this contract?
Well, the instructions that I have in every NIT of Metro Rail Corporation, this has happened. This issue has reached this honorable court earlier also. There is a clause in the by the number of 7.3.1, wherein which relates to the notification of the award.
Sir, that's right. That's right. So we know the scope limited scope of judicial review in contract matters.
So the reasons for
please listen to us. We know the limited scope of judicial review in contract matters. So we will confine ourselves within that scope. Now, suppose if a company, which according to it is an experienced company having executed or executing multiple similar type of contracts, right? ये ऐसा होता है कि भाई ये first time somebody is trying to step into this business and then we can assume कि भाई नहीं है इनके पास कोई experience.
ये जितनों का successful technically they are my I am their employer's Blot. I am executing all major projects throughout the country.
Fine. There is no difficulty.
And the state of Madhya Pradesh, the respondent Blot for
Agrawal sir, just bear with us for few minutes.
Yes.
So, Mr. Anvesh, whether the company who is declared unfit to participate in this contract, not unfit in perpetuity, वो तो फिर blacklisting हो जाती है.
जी,
to participate in this contract, right? And
Malaj,
according to the company, it is executing or it has executed major similar projects.
Malaj,
And according to them, it is a subsidiary of central government also, right?
Malaj, Malaj,
Now, once they have challenged their disqualification or holding of non-responsive,
Malaj,
now in absence of any reasons, are we in a position to adjudicate the correctness of your decision? Your decision might be right. But
Malaj.
in absence of any reason, are we in a position to assess your evaluation, because we cannot go into the suitability. It is your prerogative, right?
Malaj, yes, Malaj, but to
Whether
that
they have been rightly held non-responsive to that
Malaj,
extent, or the decision-making process, that can be looked into, no difficulty.
definitely,
For
Malaj.
that purposes, we are required to know the reasons for holding such a company as a non-responsive.
Malaj.
You could have
Uh,
done so without disclosing reasons. We are not on that issue.
Manoj,
Whether you- Yes, sir.
the suitability aspect, so far as that suitability aspect is concerned, Manoj, so far as the disclosure to the petitioner is concerned, there is a specific clause which says that disclosure will be done only after financial bid is opened.
Sir,
That
sir, okay. Suppose if we say that the final contract shall not be, final decision in the contract shall not be taken, right?
Manoj, this is a mega project.
Mr. Anvesh, you yourself has said that as per the tender, the reasons will be disclosed after the financial bid is open, right?
Manoj,
Fine. Now suppose, not suppose, as per the petition, the financial bid will be open on 29th,
Manoj,
right?
Manoj.
Now even according to you, you can or you are under obligation to disclose the reasons after the financial bid of the other contenders or bidders are open, right?
Yes, Manoj.
Now, this is the amount which has been filled up by the companies or bidders.
Yes, Manoj.
Now, suppose ultimately you are directed not to finalize the contract till 4th of November. So we have assembled because of the urgency.
Manoj.
And 4th of November will be the first day after the normal functioning is resumed.
Manoj.
Right? Now, as per your contention, the reasons will be disclosed after the financial bid is open. So, by the next date of hearing, even the reasons will be known to everybody. To everybody means to the petitioner, to you, and then the petitioner will be in a position to amend their petition also. So if we say okay, the contract shall not be finalized till 4th, you may go on with the process. We will not stop the process.
Manoj.
The contract shall not be finalized. In the meanwhile, you will disclose the reasons and then list it on 4th.
Manoj, may
बीच में इन्होंने जो amendment करना होगा in the light of the reasons, they may do that.
Manoj, may I just request if it is permissible, Manoj, may keep the, if we proceed with the finalization also, Manoj, may keep it subject to the outcome of this petition.
हाँ
Manoj.
सर, आप तो controversy और multiplicity of litigation में विश्वास करते हैं,
नहीं ऐसा नहीं है.
है ना? Finalize हो गया, अब vested interest किसी और का भी accrue हो गया.
I'll because Manoj,
आप मदारी बन के दूसरों को नचा के मजा लोगे, ऐसा कहना चाहते हो क्या?
नहीं ऐसा बिल्कुल नहीं था. मैं because I may not be in a
अनवेश जी,
position.
अभी आपने कहा था ना कि as per the tender, the reasons will be assigned after the financial bid is open. Which is that provision, sir?
Manoj, it is 7.3.1.
7.
The notification
Prior to
in
the
the-
expiry of the period of tender validity prescribed whether the employer at least 10 days after the evaluation as per will notify the successor tender in writing that the tender has been accepted. This letter, the letter shall name the sum. Yeah, this is with regard to the issuance of letter of acceptance. Where is the provision for communicating the reasons for rejection?
7 point. Manoj, 7.1.3, Manoj. The successful bid. The
7.1.3. May request in writing to that briefing seeking explanation on the ground that the tenders were not selected. Okay, sir. Anvesh ji, as per 7.3.1, you are required to communicate to the successful bidders within 10 days, right?
Yes, Manoj.
Now, if the tender is open on 29th,
We have time till 9th, Miloj.
you will have time till 9th, right? We will
Yes.
fix it on 4th, the first opening day after the Diwali vacations.
Yes,
And
Miloj.
in the meanwhile, in case if the petitioner file an application for communicating the reasons, please supply the reasons for declaring them as non-responsive. So that in the meanwhile, if they so desire, they may also amend their writ petition. Fine?
Miloj, that would be against the terms of 7.1.3.
Yeah.
We have to supply debriefing after notification of award. But if Miloj are
कोई बात
restraining,
नहीं sir, कोई बात नहीं. Are we bound by your tender conditions, or the bidders are bound by the tender conditions?
Miloj, there would be two others, then Miloj who would be same.
Fine sir, then
claiming-
we are staying the finalization. अगर हम कोई रास्ता निकाल रहे थे कि 4th को pleadings complete हो जाए, so that this big project may not come to a standstill, you are trying to create all sorts of hurdles. Right?
No, Miloj, I'll
सर,
never.
अगर आपको क्या तकलीफ है कि अगर ये कल एप्लीकेशन देते हैं या परसों देते हैं और आप इनको एक दिन के अंदर रीजन असाइन कर देते हैं,
We'll do
so
that.
that they may amend the petition, then it can be heard in the light of the limited scope of judicial review. But you
We'll
are
do that.
interested in creating all sorts of hurdles, then we are restraining from even opening the financial bid.
We'll supply the reasons, Miloj.
अगर आपको इतना है तो हम फाइनेंशियल बिड भी रोक देंगे सर.
No, Miloj. I'll. Yes, sir.
At least as a court, we are required to maintain the balance, right?
Miloj.
Their primary contention is that the petitioner is an experienced company having executed and is executing the similar type of contracts in different parts of the country,
Miloj.
right? Now,
sir.
one question is that if such a company suffers a setback in Madhya Pradesh, that where it was declared as a non-responsive for the similar
We're
project.
executing for Indore also.
मैं मध्य प्रदेश कह रहा हूँ.
मध्य प्रदेश में इंदौर में हमको 3 प्रोजेक्ट्स
Fine, fine, fine. कोई इशू नहीं है. Sir, this is too early for us to say anything on the.
We have filed all those documents.
What I am saying, it is
Yes.
too early for us to
Yes,
make
yes,
any comment,
certainly.
either this way or that way.
Yes.
Now, what I was communicating to Mr. Srivastava, that if a company, according to which it has already executed multiple contracts of a similar in nature, is executing the contracts also of similar in nature, is held to be non-responsive, then it may have some adverse effect on its reputation. Not only this contract. Had it been a case, my financial bid was second lowest, then my bid should have been accepted. That will not be any blot on their reputation. Non-responsive है, आप financial bid के लिए भी successful नहीं हो पाए. It may have some adverse effect. So what we are suggesting to you, subject to your all sorts of objections to, in case if we say, okay, you may open the financial bid, but you shall not finalize the contract. And in case if the petitioner move an application by day after tomorrow for supplying the reasons, you shall supply it within 2 or 3 days so that they may amend the petition. And we will list it on 4th. Because 4th is a day which will not be out of this purview of 7.3.1. Your contract will not get delayed.
Miloj.
Right? In the meanwhile, they will amend their writ petition.
Miloj.
और फिर regular bench देख लेगी.
Miloj.
34241/2024 Shri. है ना? Shri Sanjay Agrawal, Senior Advocate with Shri Udit Seth, Counsel for Petitioner, Shri Anvesh Srivastava, Counsel for Respondent through video conferencing on caveat. Shri Srivastava accepts notice on behalf of Respondent. Shri Sanjay Agrawal also is directed to verify as to whether the companies who have been permitted to participate in financial bid are necessary parties or not. And if so, then he may also file an application for implementing them as respondents. It is submitted by Shri Agarwal that the petitioner is executing and has executed multiple contracts of similar in nature, and without assigning or disclosing any reason, the petitioner has been declared to be non-responsive for financial bid, it is submitted that financial bid is to be, will be opened on 29/10/2024. Well, stop. Per contra, it is submitted by counsel for the respondent that as per clause 7.1.3 of the tender notice, the unsuccessful tenderers may request in writing to the employer a debriefing seeking explanations on the grounds that on which their tenders were not selected. Full stop. The employer shall respond, in writing, to any unsuccessful tenderers who, after the notification of award, would request a debriefing. Full stop. Further, by referring to clause 7.3.1 of the tender, it is submitted that the employer at least 10 days after the evaluation results of financial bids shall publish on e-procurement portal as per subclause 7.1.2. Above will notify the successful tender in as per clause 7.3.1. ऐसा है पूरा लिखना prior to the expiry of the period of tender validity prescribed by the employer, the employer, semicolon, at least 10 days after the evaluation results of financial bids are published on e-procurement portal as per subclause 7.1.2, will notify the successful tenderer in writing, that their tender has been accepted.